Notaio Antonio Zorzi. According to the website www.studio Notarile Zorzi IT, it appears to be a law firm dealing with transfer of real estate in Siena, in Italy. Now, that's as far as the applicant's concerned. Paragraph 10.3.4 deals with Deborah Agrizzi, the applicant's common law wife. Between 21 December 2018 and 3 January 2019, Deborah Cindy Agrizzi transferred a total of 11.99 million to offshore accounts as foreign investment by a resident individual in respect of the investment allowance. On 21 December 2018, 996,113 rand was transferred to an offshore account in her own name. On 2 and 3 January 2019, a further 11 million was transferred to an offshore account styled Studio Notaio Antonio Zorzi. 1 million rand was transferred from her FNB account and 10 million from her Netbank account. This followed a transfer of 10 million, two transfers of 5 million each, from her FNB account on 29 December 2018, received in a Netbank account on 19 and 31 December 2018 respectively. This, the importance thereof will become apparent a bit later, Your Worship. Yeah. The aforementioned funds originated inter alia from payments to her FNB account with a reference Ferrari to the amount of 7.975 million on 28 and 29 November 2018. Payments to her FNB account with reference BMW X6 to the amount of 1.05 million on 13 and 14 December 2018. 8 million transferred from the applicant's ABSA private banking account on 28 November 2018. R25,000 transferred from the applicant's ABSA private banking account on 13 December 2018. 50,000 transferred from the applicant's ABSA Private 1 account on 13 December 2018. 1.945 of 1,945,200. Yeah. Let me get this right. I think there's too many zeros here. It's.
Thank you, Worship. If it's extra, we'll take it.
Yes, it's not 1.9 billion, Your Worship. It's 1.9 million. 1.945 million transferred to the applicants. If we can just delete the last 3 zeros, Your Worship. Transferred to the applicants' Netbank account on 15 to 21 December 2018. And 2 million transferred from the applicant's ABSA 1 account on the 27th of December 2018. Now, Your Worship, as I will show later on, this then indicates that the source of the funds, and that's the relevance of this, the source of the funds that Deborah Agrizzi transferred to Italy was the applicant, save for 1.05 million that she received in her account for payment for an X6 BMW. But we will deal with this a bit later. So that's the importance of this paragraph. The source of the funds that she transferred originated from the applicant in this matter. Now, Your Worship, now on 6 February 2019, and that's now the date of a previous application in the other court, DC Agrizzi and the applicant had the following positive balances totaling 8.75 million in various bank accounts, and this excludes an ABSA credit card and Standard Bank accounts which we still have outstanding. I will list it as follows: 4.238 million in an American Express account, that's a credit card account, at a positive balance of 4.238 million. 27,284 rand and 93 cents in an ABSA private bank account. 493,206 rand and 35 cents in a net bank account. That's all Angelo Agrizzi, the applicant. Then 1,025,000 and 133 rand and 14 cents in a net bank account for DC Agrizzi. 247,530 rand and 37 cents in a net bank money trader account for the applicant. 22,338 rand and 80 cents in an FNB card for the applicant. 404,218 rand and 97 cents in an FNB wealth account for the applicant. 295,105 rand and 12 cents in an FNB private wealth account for DC Agrizzi. 585 rand and 41 cents and 1,426 rand and 22 cents respectively in an ABSA depositor plus account for A. Agrizzi. And then at least 2,001,540 rand and 14 cents in an unknown account or location. This amount was deposited to his Nedbank money trader account on the 7th of February 2019. So that's why we know it was there somewhere. Your Worship, it's therefore clear, that's paragraph 10.4, that the applicant misrepresented the value of movable assets belonging to himself and his wife significantly in paragraph 8.2 of Annexure A. As illustrated above, they had liquid assets, and that's cash at hand, of at least 8.576 million rand in local bank accounts or in cash. And on top of that, offshore assets to the value of at least 24 million, which was confirmed to be liquid assets in December 2018 and January 2019, as well as vehicles with a retail value of at least 2.85 million. And these amounts then, this amounts to a combination of movable assets, excluding household furniture, jewelry and art, of 35.6 million instead of 2.65 million as declared. Worship, just to get back, the significance of this remains the 24 million foreign assets, foreign liquid assets, that was not disclosed at the time. May I add, Your Worship, that today again, when the bail application was brought, no word about the foreign assets was included in that application. And as my learned colleague rightly pointed out, once it became clear that the applicant again chose not to take this court into his confidence and disclose his foreign assets, the state had no option other than to oppose his application.
Mr. Rousseau, can I ask you to contain yourself to the reading of the affidavit?
Oh.
You can retain your closing arguments for a later stage.
I apologize.
Otherwise, we are clouding what is written in the affidavit against what you are now making submissions from the bar.
I apologize, Your Worship. I will refrain from doing that. Worship, then paragraph 10.4. The payments to the FNB account of Agrizzi, DC Agrizzi with reference Ferrari and BMW X6 as per paragraph, and Your Worship, can we just amend the affidavit? There is a mistake. It's supposed to refer to paragraph 10.3.4.3, not 7.2.4.3. Payments to these accounts appears to be consistent with the disposal of assets at the time. Payments with a reference Ferrari to the amount of 7.975 million and on 28 and 29 November 2018 appears to relate to the sale of a 2014 Ferrari F12 and the 2016 Ferrari 488 GTB registered to the Agrizzi Family Trust. 10.5.2 payments with reference BMW X6 to the amount of 1.05 million on 13 and 14 December 2018 appears to relate to the sale of a BMW X6 registered to DC Agrizzi. Paragraph 10.6. Contrary to what was stated in paragraph 17.3.6 of Annexure A, the applicant does not really seem to care whether he loses the fixed property he claimed to have. This is clearly demonstrated in his conduct before and after his arrest. 10.6.1. The property referred to in paragraph 8.2 of Annexure A is bonded by ABSA as collateral for an ABSA 1 account in the name of the applicant. Although the property is bonded for 8.7 million, the facility granted was only 7.96 million. The facility was reduced from 10 million to 7.96 million on 17 August 2017 following the release of Unit 47 Savannah, ERF 166 Simbiti, Durban, as collateral for this facility. In terms of paragraph 13 of a facility letter dated 13 January 2015, the applicant will be in default of an agreement if inter alia he does not pay any amount payable to ABSA in terms of this agreement on the due date. On January 2018, the account had a positive balance of 43,182 rand and 36 cents. On 17 November 2018, the applicant owed 7,918,340 rand and 59 cents, whereafter he transferred 7.92 million into this account on 27 November 2018. And then between 1 December 2018 and 24 January 2019, this account was again overdrawn to the amount of 7.53, let me do this again, 7,953,959 rand and 52 cents. The last payment to this account was honoured on the 1 February 2019. Since then, the account has been mostly dormant. I was informed that the outstanding amount as on 12 October 2020 was 9,45,149 rand and 62 cents. And this amount is expected to exceed the potential realizable value of a property in current market conditions. The aforementioned amount exceeds the total facility granted by more than 1.1 million. In the period 1 February 2019 to date, large amounts of money was moved to offshore accounts and to cryptocurrency accounts, but the applicant chose not to make payments to this account. The aforementioned is significant given the fact that according to the applicant, he earns a gross salary of 55,000 rand per month, being his only source of income as on 6 February 2019. This was not even enough to cover the monthly interest commitment of 58,105 rand and 4 cents as on 6 February 2019. He then goes further and says, I was informed that ABSA is finalizing papers to launch proceedings for the recovery of the outstanding amount and declaring the property executable. (10.7) Since 6 February 2019, the following transactions occurred, clearly indicating that the applicant had no intent to service the debt as per paragraph 10.6. On 11 February 2019, the applicant transferred 2.15 million from his Nedbank money trader account to his Nedbank current account, and then transferred 2 million from his Nedbank current account to the Nedbank account of DC Agrizzi. On 27 February 2019, the applicant transferred 2 million from his American Express account to his Nedbank current account, and from there transferred 1.89 million to a Luno account. In brackets, Luno is a cryptocurrency exchange. On 1 March 2019, the applicant transferred 1 million from his American Express account to his Nedbank current account, and from there 900,000 rand to the Nedbank account of DC Agrizzi. On 4 March 2019, the applicant transferred 1 million from his American Express account to the Nedbank account of DC Agrizzi. He received information that on 5 March 2019, the applicant bought real estate / properties in Castel del Piano in Italy for €880,000. A contract in that respect was registered on the 6th of March 2019. On 10 April 2019, DC Agrizzi closed the Nedbank account and transferred the balance of 4,455,458 rand and 6 cents to her FNB private wealth account. On 1 April 2019, DC Agrizzi transferred 2,175,850 rand from an FNB private wealth account to the Luno account mentioned in paragraph 10.7.2 supra. On 22 July 2019, DC Agrizzi bought foreign currency to the value of 99,936 rand and 26 cents on a foreign travel allowance. From 3 to 7 October 2019, DC Agrizzi transferred a total of 774,515 rand and 61 cents from a standard bank account to offshore accounts in the name of Angelo Agrizzi as gifts and payments for cultural and recreational services. On 10 October 2019, DC Agrizzi transferred an amount of 205,480 rand from a standard bank account to an offshore account or accounts in the name of DC Agrizzi as payment for cultural and recreational services. The conclusion follows, Your Worship, wherein he says, whereas a total of 6.69 million was transferred either offshore or to a Luno and altcoin cryptocurrency exchanges, then transferred to unknown recipients' locations, and the bond is not serviced at all, it's respectfully submitted that the applicant is prioritizing offshore assets and has no intention to secure the property referred to in paragraph 17.3.6 of Annexure A. Paragraph 10.8. The transactions on the Luno account as referred to in paragraph 10.7.2 and 10.7.7 for the period 28 February 2019 to 21 May 2019 can be summarized as follows. Transfers totaling 1.89 million was reflected in this account on 28 February 2019 to 1 March 2019. From 1 March 2019 to 8 March 2019, cryptocurrency to the value of 1.89 million was purchased. The transfer of 2,175,850 was reflected in this account on 12 April 2019. On 12 April 2019, cryptocurrency to a value of 2,174,750 rand. I see I've got million on the affidavit. Your Worship, it is rand, it's not million. I repeat, it's 2,174,750 rand was purchased. On 13 April 2019, from 13 April 2019 to 2 May 2019, cryptocurrency to the value of 1,460 was purchased, and on 20 May 2019, cryptocurrency to the value of 23,176 was sold for cash and transferred to the FNB account of the applicant. Paragraph 10.8.6. Between 10 April 2019 and 15 April 2019, Ethereum to the value of 260,249 rand and 84 cents was sent to an unknown recipient or location. This is cryptocurrency. Paragraph 10.7. Between 10 April 2019 and 18 April 2019, Bitcoin to the value of 4.5 million was sent to an unknown recipient or location, whilst Bitcoin to the value of 525,000 was received into the account on 14 April 2019. I furthermore received information that between 16 August 2019 and 5 October 2019, an amount of 854,616 rand and 80 cents was deposited in an altcoin trader account opened by the applicant, and that the funds was converted to Bitcoin that was sent to various Bitcoin wallets. We are on the process of verifying this information. I also received information which will be verified by means of mutual legal assistance with our Italian authorities once we are able to do so, given the current COVID-19 crisis. The applicant operated a bank account with Intesa Sanpaolo SPA in Italy with an account number IT49 R0306914226 1000000001901. The account was opened on 12 November 2018, and Ms. Deborah Angelo Agrizzi was delegated to operate the account as from 15 March 2019, and the account was closed on 24 October 2019. The applicant is 10.2. The applicant received significant transfers from his South African bank account during 2018, whereafter 488,000 euro was transferred to the Italian bank account of Ms. Deborah Cindy Agrizzi. During April 2019, significant bank transfers were received in this account from an Estonian account at CB Payments Limited, a cryptocurrency platform. On 5 March 2019, the applicant bought real estate properties in Castel del Piano in Italy for 880,000 euro. Contract in that regard was registered on the 6th of March 2019. Ostensibly, a luxury car was purchased as well. 10.10.5, DC Agrizzi reportedly also operated her own bank account under account number. I'm not going to read this out, Your Worship, with permission of the court. Intesa San Paolo SPA in Italy. As on 30 March 2020, the particular bank account had a balance of 714,000 euro. 714,419 euro and 50 cents. Following a request to travel by the applicant, this is now paragraph 11, in July 2019, the prosecutors inquired from me whether the applicant surrendered his Italian passport to me. At the time, I was not aware that the applicant had an Italian passport, and it was not mentioned when the applicant's South African passport was handed over to me as part of his bail conditions. Whereas the applicant would be in breach of his bail conditions for not handing in this passport, the matter was taken up with his attorneys to Wits Incorporated. On 2 August 2019, the prosecutors received a letter from Mr. Daniel Wits, wherein he stated that the Italian passport was lost. This was also conveyed to me by Mr. Wits telephonically, but it was the first time that the loss of the Italian passport was conveyed to me. The aforementioned letter was followed up by an affidavit by the applicant dated 15 August 2019, wherein the following was stated. My Italian passport was lost, and after the extensive search of my house, my study and my belongings, my motor vehicle, and I have not been able to find the said passport. After my sudden and completely unexpected arrest, and whilst I was still in the process of assisting and testifying before the State Capture Commission, I did not report the loss of a passport to the Italian Consul General. When my legal representatives received correspondence from Senior State Advocate P. Serunye, may I just mention, rather leave this, in relation to the Italian passport, I again searched for the passport, and my legal representatives informed him that the passport has been lost. In view of the loss of a passport, I, through my legal representatives, will contact the Italian Consulate General in Johannesburg, inform them of the loss, and I will forward a copy of a correspondence reporting the loss. Colonel Lazarus then, this is not Colonel Lazarus continuing. I respectfully submit that the loss of our Italian passport in conjunction with the facts set out in paragraph 10 is suspicious, especially given the fact that I was not informed of a loss in February 2019, as on 15 August 2019, Italian authorities was not informed of a loss either. In this regard, I need to clarify that I was not aware of the fact that paragraph 7.5, where Mr. Agrizzi declared that he was the holder of an Italian passport, was inserted in pen in Annexure A, and I therefore did not inquire about the whereabouts of our Italian passport. Paragraph 12. I am now of the opinion that the applicant indeed poses a flight risk as he has a means of leaving the country and he chose to mislead the Specialised Commercial Crime Court Pretoria on 6 February 2019 as per Annexure A, in that he failed to mention his offshore assets. I am made to understand that if the applicant were to abscond to a foreign country, extradition proceedings would have to be followed, which can be an expensive and protracted process, especially if it's opposed. I am therefore not convinced that it will be in the interest of justice for the applicant to be released on bail. At the time of deposing to this affidavit, I have not seen an affidavit by the applicant in support of a bail application in this court, and I undertake to prioritize investigations into any new averments contained in such affidavit, if so needed, and to revert to this court as soon as possible. Bishop, this affidavit was then attested to today, the 14th of October in Johannesburg. I will then hand this up as Exhibit C. Sorry, I'm informed the last exhibit was Exhibit H. So this would be Exhibit I. J. So
No, you were misinformed. The last exhibit was B.
Was it B?
Yes.
This application was, yeah, in the specific application obviously it's B, yes. So this would then be Exhibit C.
I'll allocate an exhibit number to it in a moment.
Thank you. Thank you, Your Worship.
The affidavit by the respondent made by the investigating officer, Lieutenant Colonel Lazarus, is received and marked Exhibit C to the record.
As the court pleases.
Thank you, Your Worship. Bishop, my colleague will then proceed with the application. Cool. Yeah, Your Worship, this is in this, as far as our reply to the application is concerned. May I just add that the ill health of the applicant is not in dispute.
All right. I will permit you an opportunity for final closing address. Can we just conclude, is this the only evidence that you wish to adduce in opposal?
Indeed, Your Worship.
Thank you, Mr. Witts. You ready to submit your closing arguments?
Yes, and just before I submit the closing arguments, just if I can just reply. Well, I'll do it in argument. I think it'll be better to do it in argument, and then I can do my response to what my learned friend has now raised.
After hearing this affidavit, is that you have no intentions to submit any additional evidence? Will you stand by closing arguments?
I think maybe during this lunch adjournment I might just want to deal with certain aspects that they've raised which I believe might not be fully covered or fully explained in Exhibit B. So maybe if we can take the lunch adjournment now, I can then deal with it briefly during the lunch adjournment. Because I see what my learned friend is now raising. Because it seems to me that the submission made by Advocate Nokunyani, that until they saw our affidavit they weren't opposing bail, that can't be correct, because normally if you're not opposing bail you would get an affidavit from the investigating officer setting out these are the position, the state are not opposing, we verified the address, we've done this and we've done that. So it appears that that's not entirely correct what was placed on record, because all of a sudden a very well detailed affidavit is presented dealing with things like cryptocurrency, dealing with various things, and then they say we changed our minds. And I'll explain to you very simply why I say that, Your Worship. When I arrived this morning after, by agreement, handing everything over and handing Mr. Agrizzi over to be arrested and formally charged at Brackendown Police Station, I then received my affidavit which we had printed for his bail application. That's Exhibit A or Annexure A. Exhibit A. The minute I got to court, I immediately gave it to my learned friend. She was sitting in Advocate Wolfhard, the senior state advocate who runs this commercial crime court in respect to the court roles and the aspects that deal with this court. Within a few minutes, Advocate Wolfhard had to be excused. He went to go and make certain copies, and my learned friend then handed me what she says is a pack. And in the pack was this affidavit, Exhibit C, which has now been handed up, which we got for the first time. So it couldn't have been prepared now this morning, because I just received immediately a copy. Also a draft order in the event of bail being granted, together with various submissions in regards to conditions. So the very first time that we ever saw it was now. So it couldn't have been something that was not done or was done this morning, like when we prepared our supplementary or our Annexure B. So that is the first position that I just want to place on record, and I want the court to take note of. Now, if there was any application or any suggestion in relation to the passport, the submission that I'll make very, very simply, and I'll deal with it in my closing address, Colonel Lazarus, from the outset, was in court in Pretoria on the 6th of February. The arrangement was that we will not arrest your clients. Please come to our offices at 63 Beatrix Street. There we will process them. There we will arrest them. We'll then take them to court, where we met Advocate Nokunyani and Advocate Sarunia, and then we presented the affidavits, and they placed on record no flight risk, no problem. What happened is, when we prepared the affidavit and I was going through everything, Mr. Agrizzi said, sorry, I also have an Italian passport. So Colonel Lazarus was present in court where we wrote it in. It was written in by hand, initialed and signed, and he was present when I read it into the record. So to suggest, as he says now under oath in paragraph on page 15, that this took him by surprise, he was unaware that there was another passport, etc., and he didn't deal with it, is, to put it mildly, not entirely correct. I don't want to take it any higher than that. He was the one that was present, he was there. When it became an issue at a later stage, when Mr. Agrizzi wanted to travel, it was then raised. We immediately found out what the position was, and we informed the state. So this is an important aspect that we'd like you to take into account. Now,
all right, can we leave that for your closing
for my
argument?
closing address.
Let's not
Fine.
do closing argument before we do closing
Fine.
argument.
So if I could just take this lunch adjournment, because it is now the lunch adjournment which is now approaching, and then I could just reconsider certain aspects the state have raised, and if I could just maybe have the opportunity to speak to my client who's in custody and deal with it, and if necessary I can then put in a further affidavit dealing with these aspects, and we can then deal with it immediately after the lunch adjournment. I'd appreciate that.
Right.
I'm not sure of the attitude of my learned friends to that, but it is the lunch adjournment fortuitously, or it's just so happened time has elapsed.
I think your request is reasonable, just to consider your options and take instructions from your instructing attorney and your client. I just want to leave you with this, Mr. Witz. I hear you coming back again and again, and clearly you feel very aggrieved by the fact that you deemed your colleague for the respondent did not play open cards with you in notifying you that they're going to oppose you. You were caught by surprise. This is very clear.
No,
But we can hover over this now, continuous, and I can hear how you feel aggrieved, and I can hear counter submissions by the respondent. But let's keep ourselves and our energy focused on what I need to decide on. Is it in the interest of justice to permit your client to be released on bail or not?
Yes.
So let's contain ourselves to that. Okay?
I'm happy with that, but I just felt that it was in everyone's interest, including my client, and as an officer of the court, and in the court's interest, and I think now the media are in the public's interest, that people in the Republic they have to know that when you're dealing with court cases, there's a certain procedure and a way to conduct a case, and things should be done openly and candidly. You don't ambush your opponents. That is that is the point. But I take your point, and I will concentrate my energies on the other aspects relating to bail and the discretion and the interests of justice. I think that is correct, and I take up what your worship has said. Thank you.
Let me ease your concerns on that. I've noted what you said. I am now aware of that you were taken by surprise. But let's focus on what I need to decide on, so we can get to a result as speedily as possible.
Thank you. I'm indebted to the
court. Thank you. We will then take the lunch adjournment. Court adjourned.
All right, isn't God?
Coming from the Palm Ridge Magistrates Court, the